Welcome all viewers, and in this show, all your questions are going to be answered, and you are going to know more. We are demystifying. Welcome, sir.
Many thanks, Faith. Welcome to Muthomi and Karanja Advocates. It is indeed an honor and a great pleasure to do this interview. Perhaps before I introduce myself, I should begin with the disclaimer that I'm not a senior counsel yet. And the only reason this is important is that the phrase senior counsel has a specific legal meaning, which many citizens are not aware. I'm, of course, a senior lawyer to the extent that I have practiced law for about 16 years now. But a senior counsel is an official rank conferred by the President of the Republic. I haven't yet applied for the conferment of that rank because the process has not been opened yet. I believe if it were, then I would be eligible. Back to the introduction. My name is Muthomi Thiankolu, and I am a partner at the law firm called Muthomi and Karanja. We are mainly in dispute resolution with a specific focus for my part on public law type of dispute resolution, legal consultancy, and I have generally specialized in matters to do with public procurement law, matters to do with pensions law, matters to do with constitutional and administrative law, or which some other people call judicial review. I have, of course, occasionally done periodic type of disputes like election petitions, which are fairly specialized type of proceedings. I have additionally been a lecturer at the University of Nairobi Faculty of Law since the year 2011. So that will make it now about 13 years and counting. I was promoted into a senior lecturer just the other day. Basically, that is what I do. My other partners, Karanja doubles up in dispute resolution with emphasis on civil and commercial type of disputes, debt collection, the ordinary property transactions and whatnot. We have another partner called Sterling Moshiri, and his expertise lies in tax consultancy. And basically, the core of our team is the three partners. We are supported by many associates, paralegals, and staff in rendering services to our various clients. Yes.
From the look of my eyes,
Yes.
I feel, if not introducing myself, if not a lawyer,
Yes.
I would say like you are a business magnate or any other person. So, what inspired you to pursue this career in law, and what led you also to specialize in this area? Because there is other parts of laws that I know. There are other sub parts, and you can tell us more about that.
When I was called to the University of Nairobi as an undergraduate 23 years ago,
Yes.
I was initially called to study engineering.
Yes.
And it's only after I went there and discovered that engineering was not properly aligned with my natural talents
Yes.
and abilities to the extent that I am the type of person that is inquisitive, that questions things. I found in short that even though I've been called to study mechanical engineering, it was not well aligned with my personality and my talents and gifts.
Yes.
And that's how I transferred to study law,
Yes.
which I believed was a course more aligned with the type of person I am.
Yes.
And looking back 23 years down the line, it is clear that I actually made a good about turn
Yes.
to quit the Faculty of Engineering and join the Faculty of Law. What has inspired me to specialize in the matters I told you about? Early on, when I was finishing my legal training at the University of Nairobi, and the Kenya School of Law,
Yes.
there was a concern which I believe still preoccupies many young lawyers today, that the legal profession was expanding exponentially in terms of numbers, and that most of the lawyers were scrambling for very small spaces of professional practice
Yes.
at the law courts, doing tort law, civil litigation, and other things. And yet there was this concern. There were many areas of potential practice that many advocates did not invest in mastering the requisite skill and knowledge to practice in those areas. And in short, what inspired me and what still inspires me today
Yes.
is I've always trying to avoid crowded spaces, things that we call them run of the mill type of legal practice. You know, every lawyer can do some things. Every lawyer, for instance, can handle a defamation claim. Every lawyer can handle a motor vehicle accident claim. So for me, the overbearing and overarching concern has always been to continually ensure that there are new and emerging areas of legal practice that are not crowded by the thousands upon thousands of lawyers that have incrementally joined the profession in the last 15, 16 years.
Yes.
And that basically then there will be, I would stand out. There will be something special I'm offering in the market for legal services that is not characterized by this problem of overcrowding. So that's how I found myself doing election law when we had the disputes that ensued after the post-election violence of 2007, 2008.
Yes.
That is how I found myself delving into public procurement law and practice.
Yes.
An area that, again, was new. I recall the law on public procurement was actually brought into effect just when I was joining the profession in 2007. And I've continued that approach. It is much later on I came to invest a lot in understanding pensions law, and many other things that I can't just mention off my head. But the long and short of it
Yes. Yes.
is that at Muthomi and Karanja Advocates, and speaking for myself, we always endeavor to see what are the areas in the market for legal services that are not well serviced, because perhaps not many lawyers are interested in acquiring the knowledge and skills in that area, or for whatever other reason, it is perhaps just too new, or it is for whatever reason neglected. So you can say, if you like, that we are some sort of a niche law firm, in the sense that we offer specialized type of representation and advice in areas the typical lawyer might not be even interested in investing their skills and time to master.
Yeah, that's what makes you unique and to stand out.
I would say so.
Yes. So, can you share to us some of the notable cases or projects that you have worked on in the past that also have had some significant impact on your career? Some of the notable, like those ones that.
Oh, there are so many. I'm one of the few people my age who have been lucky right from straight upon admission to the bar, done cases that set precedent, opened new areas of the law, established new rules that were either to unknown. And there's so many. I don't know which ones I would mention, but for purposes of answering the question, one of the most important ones, of course, was in electoral law. I drafted a petition immediately after the post-election violence relating to the dispute in South Mogirango. I recall it was between Mingo Magara and Manson Memorial, and this case was later on taken over by Mr. Mwanza Mbati, who is now recently elected as the LSK representative to the Judicial Service Commission. Why this case was important is that it made a complete departure from what had been the approach to electoral dispute resolution in Kenya, which was focused on legal and procedural technicalities and avoiding judges avoiding to deal with substantive complaints. You recall that is the very reason there was a post-election violence, because the aggrieved side and said they will not go to court because going to court was pointless. There were just too many incidents in the past where the courts, faced with an electoral dispute, chose to elevate procedural and legal technicalities. And basically, this case established what now lawyers routinely refer to as the qualitative and quantitative tests of the validity of an election. I consider this matter to be important. Together with the related matter I also did between Beth Mogo and John Kerry Waweru, because of their contribution to the whole question of electoral justice in Kenya.
Yes.
And the fact that I was so young, just newly admitted,
Yes.
and I was appearing against very seasoned, very experienced senior lawyers, some of them old enough to be my parents or grandparents. And yet I somehow acquitted myself extremely well in those two assignments. I would mention another one, done still in those early days. It was a dispute in public procurement. And again, why this dispute is important is it revolved around the mischief then common in our public tendering systems, whereby corrupt government officers would receive kickbacks and bribes from a tenderer, and then somehow if the candidate that offered the best deal to the government was not the one who had bribed them, they would terminate the tender proceedings and restart them afresh with a view to skewing the procurement in favor of corrupt suppliers and whatnot. And why the dispute is important is one, it established a precedent which was then unimaginable, that government officers, and notwithstanding what appeared to be the plain text of the law, could not just terminate a tender without assigning reasons for it, and at any rate could not terminate it if the processing of that tender had reached certain milestones. At both cases, if you check on the internet, the Manson Oyongo Nyamoya, the Selects case, are cases that are as cited if you search on the Kenyan law reports. They are some of the most frequently cited cases ever every day in our courts. Perhaps for purposes of public law. Only less famous maybe to cases like Narita Karimi Jero versus Republic and Yedenguri versus Republic. In those early days, those are the cases among very many others that come off my mind. In the recent days, of course, I have again been fortunate to do very high profile and high stakes disputes. One of them, of course, that most people recall vividly was the presidential election petition dispute of 2022, in which, as you would know, I was one of the lawyers that was playing a central role in defending the victory of our current president, His Excellency William Samoei Ruto. And specifically for me, why that case is important is that one, the dispute is determined on the merits, and the courts, without relapsing to the old technicalities of law and procedure, have actually begun calling out people who bring out or rather who file frivolous or unmerited electoral disputes. You recall there was this thing about hot air, what goose chase and whatnot. Um, then recently I've been involved in this dispute on the National Social Security Fund contributions, a huge dispute about the constitutionality of the national NSSF law of the year 2013. It is an important dispute in the sense that that law basically affects every employer and every employee in the Republic of Kenya. It is important to the extent it was fought all the way to the Supreme Court. It has now been referred back to the Court of Appeal. It is important because it settles an important question, which is the limits of the jurisdiction of specialized courts we established with the new constitution, specifically the Employment and Labor Relations Court, which the constitution says are the status of the High Court, but confined to employment and labor disputes. And the specific question was whether a dispute relating to the constitutionality of a law that establishes a pension scheme, in this case, the NSSF Act of 2015, is a dispute for determination by the High Court, as the court primarily tasked with interrogating the constitutionality of statutes, or whether such a dispute could be determined by the Employment and Labor Relations Court. And the Supreme Court has ruled that to the extent that there can be no claim to a pension in the absence of an employer-employee relationship, then it is the Employment and Labor Relations Court that should have had that dispute. I've also undertaken many consultancy assignments that I consider truly, groundbreaking, precedent-setting, or at least historic, at the risk of perhaps overblowing the importance of some of the assignments I did. As you must be aware, last year I was heavily involved as the lead of the technical team on the part of the ruling coalition in the national dialogue negotiations that were taking place at Bomas as a means of, resolving controversies relating to the presidential election of 2022, cost of living, and many other issues then flagged by the political class, both on the government and opposition side, as matters that were important to Kenya. And it's an assignment we delivered quite successfully. It had its own challenges. But we submitted the report to the president, I think 2 or 3 weeks ago. I don't recall the exact date. I would consider that perhaps one of my small contributions to ensuring the peace and stability of my country. I have also done important assignments for the international community, for both the World Bank, the East African Community, the United Nations Office on Drugs and Crime. The World Bank and EAC ones have largely been consultancies on efforts to entrench the East African common market. When we talk of the East African community, many people don't know that the essence of establishing that community is to enable citizens of the member countries to invest and do business and live whenever they find best promote their interests, so that you're not confined to your national borders. You can go set up business in Uganda, in the Democratic Republic of the Congo, in Burundi, Rwanda, Tanzania, all these member states. The idea behind the East African common market is you have something called right of establishment. You also have a right of residence, which means you should be able to do business across all these national borders within the East African community. without being treated like a foreigner. Because if you're treated like a foreigner, then there are many, tariff and non-tariff barriers to trade in terms of customs duties, import duties, and many other restrictions that may make it very hard for you to compete perhaps with the local investor or the local businessman or local manufacturer. There are also, of course, many other tax implications. There are many technical barriers that you could face relating to standards, sanitary requirements, and whatnot.
What are the benefits like they work without permit or
No, it's not
passport?
like you're exempted from regulatory requirements. It simply means, across the world, if you're trying to do business across national borders, you generally are not treated the same way like the person who is a national of the country where you're seeking to sell your goods or services. So the whole essence of regional economic integration, like the arrangements under the Treaty for the Establishment of the East African Community and the Protocol on the East African Common Market, is basically to consolidate, to have all these 5, 6, or whatever number of countries treated as a single market
Okay.
for purposes of business, investment, trade, and all those things. So that although politically each of them is a sovereign state, Kenya is a sovereign state with its own government, its own leadership, Tanzania the same, and other countries, but the idea of economic integration is to ensure, notwithstanding the separate political identities of the various republics, when it comes to doing business, when it comes to investment, when it comes basically to any economic activity, and every human being engages in one or other form of economic activity, then you have a bigger market. You're not confined, or you don't face unnecessary restrictions trying to buy or sell or whatever you produce or distribute across the borders.
Yes. Okay, I have another question. All those questions very well answered. What would you believe sets your approach to practicing law apart from the others? I think you are touching it. Apart from other law firms.
There are many things that distinguish our legal practice from the typical legal practice. One of them, which I've already told you, is we try to concentrate more on the neglected areas of practice that other lawyers, for whatever reason, may not be very interested or incentivized to practice in that area.
We already have a niche.
Yes, so we are more of a niche type of law firm. The other thing that distinguishes us is that we have invested very heavily in ensuring that when we do our lawyering, we are so good that the client or even the adversary must acknowledge that we are among the best that the world can offer. And this is the reason, if you just do your Google search, cases we've been involved, there are really cases at the very highest levels you could get in any country. And the presidential petition, the dispute like this one on NSSF, disputes such as those relating to the county pension arrangements, disputes like the procurement ones I just told you. Basically, I would say, speaking for Muthomi and Karanja, we have been there and we have played at the very highest levels. Any lawyer would wish in a lifetime to be. I don't believe there is a case of a level of importance, whether to the clients or to the entire country, or there is a case of a level of complexity or the required a special type of experience and ability that we haven't been there. So one of our frustrations is then what do we do next if we are only, like for me now, I'm 43 years old, and you've done cases, lawyers who are in their 70s have never done. There are lawyers who have retired have never done, and then you have all these years ahead. One of the challenges then is what next, because there is always a risk of either now plateauing
Mm.
or declining,
Mm.
or perhaps maybe venturing now international and forgetting the domestic level of legal practice.
Mm.
And basically, what has enabled us to achieve that is, for lack of a better word, at the risk of overblowing it, by
Mm.
being extremely good
Yes, yes.
in the things that we do.
Mm.
And there are no two ways about that. In this farm, it's either we do it
Mm.
like it's the last thing we'll ever do in life, or we don't pick it up at all. And for me, that commitment to excellence is perhaps what has enabled us to achieve some of those milestones, while we are still a fairly very small, very young legal firm.
And I think that one touches to our next question, which you will give us as your opinion. What are some of the most common misconceptions or misunderstandings that people have about this your nature or this your specific area of practicing law, this public law or this international law?
There are many misconceptions about public law disputes.
Mm.
One of them is, many people have this assumption that government is just evil and corrupt and incompetent,
Mm.
and therefore that's the reason you find all these things,
Mm.
challenging these laws unconstitutional, or the other arrangement unconstitutional. And it might be it's not true.
Mm.
Most people just don't realize how complex the whole business of running the entire state is.
Mm.
And given the sheer size of the bureaucracy involved in running the state,
Mm.
it is inevitable that there will be disagreement.
Yeah.
It is even inevitable that occasionally mistakes could be made
Okay.
and whatnot. The other misconception I've found is that many people, both on the side of government and the citizenry,
Mm.
don't see the value of engaging lawyers early on.
Mm.
They only call on lawyers when there is a problem. And I think this is a uniquely Kenyan thing.
Mm.
You realize most Kenyans contract a serious disease.
Mm.
They will only see the doctor when the disease is unbearable. Sometimes, unfortunately, they have waited for so long for some diseases like cancer.
Mm.
It is now terminal.
Yes.
Yet, if they had reported that initial stomachache, that initial fever, that initial diarrhea to a doctor,
Yes.
while maybe the illness was at stage 1,
Mm.
they would not have died.
Mm.
It is the same with the misconception that many people
Mm.
approach legal issues. There are many times I see both government and private business and private individuals expend so much money
Yes.
to resolve a problem, a legal problem,
Mm.
that would have been avoided in the first place
Mm.
if only they had invested in involving lawyers right from the conception of the project, right from the conception of the law in question,
Mm.
and preempted
Yes.
problems. So for me, that's one of the major misconceptions. And the misconception runs this way, that it is not necessary to engage a lawyer yet,
Mm.
or it is a waste of money
Mm.
to engage a lawyer because there is no problem yet.
Mm.
And yet, if you engaged a lawyer, the lawyer would clearly see what you're setting out to do and foresee problems and tell you. If you embark on this path, you definitely.
Mm.
So I don't know how that can be fixed.
Mm.
We are, of course, subject to the usual misconceptions,
Mm.
both in Kenya and across the world. There are very many misconceptions about lawyers.
Mm.
Some people don't think lawyers are a truthful person.
Yes.
Some think lawyers mislead and financially exploit clients and whatnot.
Mm.
But I can tell you without any fear of contradiction that the typical ordinary lawyer, both the famous and the not famous,
Mm.
both the successful and the not so successful, majority of them are very honorable.
Mm.
and the majority of them would never take advantage of a client in the name of making money or extracting a bad share of them. But then there we are. Sometimes, when lies are carried across generations, across years, they acquire an apparent element of truth, even if when subjected to actual qualitative scrutiny, you would find they are not accurate. They are just misconceptions.
But in every field, there exists some.
Of course, just like there are rogue priests.
Yes.
There are rogue doctors.
Yes.
There are rogue police officers. There are even rogue teachers, who molest pupils and students. There are even rogue parents. We take it for granted that every parent is a good parent. But if you've been, for you who does your journalism at Milimani Local, I'm sure you've encountered countless unfortunate incidents that involve parents against their own blood, their own children. So I'm not trying to suggest that the law profession is a profession of angels. Far from it. I'm only trying to say that the generalizations and stereotypes that you find flying around are not accurate, and they cannot be a good, fair, and correct depiction of the general nature of the profession and its members.
Yes. How do you keep updated? How do you stay updated on the changes and developments in the law within your practice area?
There are only few ways of doing that. One, not just in my practice area, but for me, I subscribe to various databases that give legal updates on development, not just in Kenya, but across the world. For instance, I've subscribed to decisions of the United States Supreme Court. So anytime they read the decision on an important matter, it will be on my email. I've subscribed to decisions of the Canadian Supreme Court. I subscribe to the decisions of the Kenyan courts on the Kenyan law website. I am, of course, a teacher, as I told you earlier on. And in my teaching, I must, of course, remain current and up to date. Otherwise, students will start rioting. But this lecturer is teaching as law that is obsolete or repealed or that is no longer the law. So, in short, the only way a lawyer can remain abreast with the developments in the law is to subscribe to the relevant updates from the various
How do you discuss? Thank you very much, sir. How do you discuss any recent legal trends or emerging issues that you find very interesting or relevant?
For me, the one part that is interesting right now, there has been, of course, this altercation, if you like, standoffs and accusations between the judiciary and the political branches of government, between the parliamentarians, the politicians, and the president. And basically, there has been the allegation on one side that the courts are out to frustrate the legacy projects of the current administration. That's one topic we should.
Yes. Like they are being intimidated.
Yes. Or like they're being intimidated to uphold some and whatnot, or like the executive wants to control the judiciary.
Yes.
Whereas it may be hard to verify the accuracy of some of those claims and accusations and counter accusations.
Yes.
For me, while this, I recall being in forums where I've been trying to tell members of both the judiciary and the executive that some of these occasional quarrels across the main branches of government are actually very healthy.
Oh, okay.
for our democracy, and that there is nothing unique
Mm.
about them. I recall a few days ago I was telling one of the leaders of one of the branches of government that are you aware, you people, that this misunderstanding you have in America, for instance, has existed since the year 1803 when the American Supreme Court ruled in a case called Marbury v. Madison that the judiciary could review for constitutionality administrative and executive actions of the political branches. I was reminding them that as we speak right now, there is a topical issue in the UK
Yes, yes.
between the judiciary and the political branches of government, in which the judiciary has ruled a plan by the UK government to settle asylum seekers in Rwanda, and the British courts have ruled all the way to the Supreme Court that that plan is unconstitutional.
Yes, yes.
I was telling them some of the disputes we were doing, I think 2 or 3 years ago now, like the BBI case, in which the issue of whether the political class can amend certain parts of the constitution and whether the court could declare constitutional amendment and constitutional things they were calling fancy things like basic structure of the constitution. And I was asking, one of the leaders of key branches of government, are you aware this has been a persistent issue in India for more than 40 years now and counting, and it has not been resolved? And I was taking them back to America and said things like LGBTQ, things like Obamacare. So for me, I think what I've been lost because we're a country that is obsessed with antagonism, and we tend to overhype misunderstandings and disagreements, especially members of your profession, the media. What we miss out as we hype the disagreements and accusations and counter accusations is that actually the very existence of those accusations and counter accusations and frustrations is evidence of a working and developing and a fledgling democracy. And there is nothing unique. Every country that thrives, I'm using the word deliberately because not all countries that claim to be democratic are truly democratic, but most of them they encounter these things. Right now, as we speak, there is an issue in Israel. It has recently been overshadowed by the war in Gaza about whether the prime minister could do certain changes to stop the judiciary there from questioning certain programs of government and whatnot. And this is a topical issue there as we speak. I could go on and on and on. So that for me, to summarize on this question, when I was in this forum, I was telling them what would worry me is not their absence, is not the presence of those accusations and misunderstandings across the three branches of government. It is actually camaraderie and the absence of conflict across them that would worry me the most. But if they are worrying, if they are fighting and arguing and disagreeing occasionally, as long as it's not all the time or none of them is on the extreme, to me, that is evidence of at least a fledgling democracy. That, the executive can tame the courts to some extent, the court can tame the executive, and parliament can tame both. All of them, of course, to limited extent in what, of course, the technical legal guys call a system of checks and balances.
But if one overshadows the other, now it becomes
Of course, overshadowing is not acceptable because the moment, if the judiciary, for instance, overshadows parliament and the executive, then you have what some critics call a juristocracy. It's called a juristocracy. Now it's ruled by judges. It is no longer a democracy because judges are not elected.
Yes.
And of course, if politicians enact laws that are not reflective of the popular wish of the people.
yeah.
And there have been allegations, for instance, that the current parliament and even previous ones are not always necessarily enacting laws that reflect the popular sentiment, the popular wishes. If that is happening, then it is not democracy. You may claim that parliament is democratically elected, but the moment it starts going contrary to the wish of the electorate, enacting laws that hurt the electorate, then it's no longer democracy,
Yes.
in my view. And the same thing if you have an executive that is overbearing on parliament and the judiciary, then you have what we call a dictatorship.
Yes.
Yeah. Kenya has seen elements of, executive dictatorship. It has seen elements, in my view, of parliamentary dictatorship, and it has seen elements of even judicial dictatorship. We only tend to be a bit more worried when the executive seems to have dictatorial tendencies because, unlike parliament and the judiciary, the executive also controls the command instrument of the state. It can coerce you to do things through the army, through the police, through the paramilitary agencies. And of course, it is known from history that the judiciary is the least dangerous, for lack of a better word, arm of government, in the sense that it's not elected, it doesn't control finance, it doesn't control the instruments of coercion. There is an assumption that the next least dangerous branch of government is parliament, because it is elected by the people, and at least in theory it is supposed to be an embodiment of the collective will of the people.
Yes, yes.
And of course, there is an assumption in theory that the executive, being the largest and most resourced agency of the state, which also has the powers and tools of coercion, is the most dangerous. But these are all just theoretical models and assumptions. In the real world, they play out very differently. And the solution from a legal point of view is to have a constitutional design that doesn't enable either of them to overshadow your word or to be overbearing on the other two. And so far, my personal view is that the model we have is working. It is not perfect. It has never been perfect, and there is no country in which it is perfect. But it is working, and we must always keep that on the vision there. How can we make it work?
Okay, thank you very much, sir. What advice will you give individuals or businesses who are seeking legal advice in this area of your expertise?
That they should feel free to engage lawyers right at the outset of whatever program or project or deal they're getting into. Because as many people say, we were taught in lower primary that prevention is better than cure. The reason many lawyers or many people being lawyers are expensive is because clients only see the lawyer when the problem is already out of hand. And yet, if they had seen the lawyer when conceptualizing their project, their business deal, when establishing the organization, when entering into whatever relationship, chances are that the lawyer would craft for them an arrangement that is less prone and less likely to end in the type of problems that usually arise when there is later on misunderstanding and the matter has to be resolved by a court of law or an arbitral tribunal or a quasi-judicial tribunal.
How would you approach a client? How would you approach your client, communication and collaboration, to ensure that their needs are met and also their expectations are managed very effectively?
For us, the model we have, which I believe every other serious law firm has, is called the participatory solution. So that once a client has given us instructions, this is my problem and I'm seeking your advice and your representation if it comes to it. We just don't take some ivory tower position and tell them, yeah, this is the solution we prescribed for you. No. Of course, you apply your mind because that's why they pay you, and because you're the one who knows the law, and come up with proposed solutions. In most cases, not just one, but several alternative potential solutions. Then you sit down with your client and you discuss each of the potential solutions and approaches
Yes.
and agree on the one that is most optimal. Professionally, that's how a lawyer should render the service to their clients. That's how we do it at Muthomi and Karanja.
Okay. Can you share any, as we continue now to finish, can you share any strategies or best practices for avoiding legal disputes or minimizing legal risks in your field? Some
It is just
strategies.
those ones I've said that involve the lawyers right from the outset.
Yes.
Number two, the reason we have all these disputes, not just in Kenya but anywhere in the world, is because of human nature. Unfortunately, we live in a world where once in a while, in the millions of human engagements and interactions, one party tries to be too clever or too impatient. I usually tell people if there were no human vanity, greed, and impatience, three things vanity, greed, and impatience, there will be no need for law.
Especially greed.
Yes, there will be no need for law. And if there will be no need for law, there will be no need for a justice system, which means you will not need the police, you will not need the prisons, you will not need lawyers, you will not need the military. But because human nature since antiquity, since the origin of time, is such that the incidence of greed, vanity, and impatience across human populations is a sad reality of human existence. Then you find law and the justice system are the only tools then for ensuring that when disputes arise, and they must inevitably arise once greed, impatience, or vanity or combinations are at play, then that those misunderstandings or disputes are resolved in a manner that is peaceful, that is efficient, and that is sustainable. Because without law and order, then what you would have is a system of everyone to themselves, people picking weapons, seeking justice on their own terms, and that would be, we were told way back in law school, how I'm not sounding too academic, that it would take us to a state of nature or violence of all against all, which, according to one of the legal philosophers people studied in law school, were told life then on earth for mankind will be short, nasty, solitary, brutish, and short, because everyone will be exerting their own justice based on their strength and whatever means of coercion they can. And the reason government exists, the reason civilized society exists, is actually the number one reason why you need the government, why you need the state and all its instruments, is maintenance of law and order. Which becomes inevitably necessary because of human vanity, greed, and impatience.
Very interesting, sir. Now, I've heard from you, it's like there is a lot of satisfaction in your field.
Yes.
Most of the times I've heard you, it's rewarding. Are there some of the challenges now that you face?
Of course, there are very many challenges of being a lawyer in general, and more specifically being a lawyer at my type of level. One of them is the job is just too demanding. You have just to do too many work hours. I can tell you, on a less demanding season, I work on average maybe 14 days. 14 hours a week. A day. There are times I have to work
Mm.
uh, sometimes as much as 16 to 18 hours in a 24 hours.
Mm.
There are many times because of the nature of the job, you are travel far away from your family. There are times you may have, speaking for myself, there I can't count the number of times, for instance.
Mm.
I've been seated on this desk working from dawn to dusk or to late on a public holiday, on a Sunday, on a Saturday,
Mm.
yet everyone else.
Mm.
So it's a job where you can be pushed to work very many hours
Mm.
if you are to deliver.
Mm.
So for me, that's one of the challenges. The other challenge is misunderstanding
Mm.
from both clients and the public
Mm.
as to what the nature of the job is. For instance, many people don't know this, but when I represent you as a lawyer,
Mhm.
my duty is not to win the case for you.
Yes.
My duty is to put your case forward
Mhm.
in the best way I can based on my abilities, my preparation, and the resources at my disposal.
Mm.
Sometimes when cases don't go
Well,
the way the clients would have wished them to go,
mm.
then you find they blame the lawyer, even
Yes.
when their case will never have turned out differently,
Mm.
even if it had been handled by
Mm.
well, that challenge for me because of the nature of cases I do, which are public law cases.
Mm.
And the problem with public law cases
Mm.
is that politicians often are invested in the dispute and its outcome.
Mm.
And you find then the position you take, you will have to annoy the politicians on this formation or the other formation.
Mm.
And sometimes they are supporters
Yeah.
then associate you with the cause of the politician.
Mm.
I'll give you an example. For instance, we've been involved recently in impeachment proceedings against the governor of Meru County.
Mm.
You see, a person who has risen to the office of governor will inevitably, or president in the case of the presidential petition,
Mm.
that's a person followed by thousands upon thousands, sometimes millions of people. And if you're whatever position you take in that political district,
Mm.
then their supporters see you either as
As
an enemy
of the other.
of the other side or as a friend of this.
Mm.
And yet all you're doing,
It's your work. It's your
you're just
good
doing a job. Just like when the doctor gives you a prescription to cure, say, typhoid. It's not because the doctor loves you
Mm.
or would lose anything if you die of typhoid. It's just that that's their job.
Yes, yes.
When you present yourself before them with certain symptoms, they must do a diagnosis
Mm.
and a prescription. Sometimes the prescription they give you doesn't work and you die.
Yeah.
I don't know why people don't blame the doctor when
They
the
blame
patient dies, but when the case doesn't go according to the expectation, they blame the lawyer.
they say that they are either one political party lawyer or what, but you don't take sides. Eh?
So one of the problems is, for me, too many of times I'm associated with the political cause of one side in a public law dispute, which would inevitably have, loud rings of politics.
Okay. What do you see? How do you see the future of the public law evolving, and what impact do you think it will have on individuals and businesses? Will it evolve or?
The answer to that question depends on the trajectory our democracy will take in the short term, medium term, and long term. Generally speaking, across the world, in the last 5 years, there has been a decline in democracy, not just in Kenya, but across the world, and there are global reasons for this. Usually, if you are familiar with world history, between 1945 and 1991, we had what some people call a bipolar world. That is to say, a world in which there were two opposing superpowers, the USSR and the USA. And if you're familiar with the world history, that is the period during which we saw the Saddam Hussein's, the Mobutu Sese Co's, the Muammar Gaddafi's, basically all the tin pot dictators the world saw in the last century and parts of this century emerged and thrived during that period between 1945 and 1991. But from 1991 to around 2012, then democracy started an upsurge across the world because it was a world with a single superpower, and that single superpower was one that espouses, at least in theory, and at least rhetorically, democratic ideals. Today, in the last 5 years, we are incrementally moving to either bipolar or multipolar world in which there isn't now a single dominant superpower, but two or more superpowers. And what appears to be happening is a return to the epoch of 1945 to 1991, in which you have now the superpowers of the Western hegemony and other superpowers of the Eastern hegemony that don't necessarily believe in democracy, human rights, some of these nice things our constitution says. So what I envision will happen is that in the short term and medium term, we will witness an increase in public law type of disputes, human rights, constitutional law, administrative law. We will witness a decline in the quality of democracy that especially that world countries like Kenya practice. How eventually things will pan out in the long term for me will depend whether in the long term the world is multipolar, bipolar or unipolar, and out of the superpowers, because clearly the world of the future will be a world of two or more superpowers, which is the dominant one. Economically, militarily, is it the one that espouses democracy or the one that is more skeptical about democracy? So I don't know how things will turn out in the long term, but clearly in our lifetime, we will continue witnessing all the altercations you have seen recently between the government and the judiciary and the legislature. They will continue to increase. At the end of the day, of course, it depends on what is the general choice the people of Kenya will prefer. Is it to consolidate and improve on the democracy, or is it perhaps to say this democracy is not working, therefore we can interfere with it, we can tinker with it, say for development, say for stability, say for this. You had in during Uhuru's tenure the call for a gentle dictatorship, and those conversations were much louder then. Today I think they are much more muted because the political class isn't very sure right now on whether such conversations will be palatable. But I can tell you they are still in the back of the minds and souls of the political class. And that's why I say there is a future. If, of course, in the long term, Kenya consolidates democracy, human rights, good governance, then it will mean there will be much to practice in terms of public law.
So even the issue of the election and other things we are seeing now, even if I elect someone, but they have already dictated me.
That's true. So basically, for me, the question is, maybe the question you should have asked is, what is the future for lawyers? Not just public law practitioners.
For lawyers.
And if it is a general question, unfortunately, the future is bleak because law is one of the careers that are seriously threatened with the risk of becoming obsolete, therefore necessary because of the rise of artificial intelligence, big data, and all these technologies currently emerging. So that I foresee a world in which, in the not too distant future, perhaps even during our lifetime, most of the work the typical commercial lawyer does will be done by a machine. You just whisper to a computer like this, you tell it, I want to purchase plot number this in Laboratory, and the owner is paid, and the machine will generate the sale agreement. And you don't need to see a lawyer or to pay a lawyer fees for that. I suspect we are going to a world in which you again tell a machine, I am in dispute with it of a commercial agreement we entered. What are my prospects of succeeding in court? And the machine, using big data, artificial intelligence, and whatever, will quickly tell, in a matter of split second, analyze that argument and tell you your odds of success is 0 or 20% or 5% without you having to walk to a lawyer's office. So most of the things lawyers do, especially the bureaucratic, run of the mill, routine type of
service and other things,
will become extinct. And let me remind you, there was a time this world the fairly distinguished and respected professionals who were called copy typists. Their duty was to type. And people went to college to learn that, and they pursued an entire career on that. These days, nobody hires anyone to type their documents. You just go and type your work. So that career now is extinct. We had a career of people who are called telephone operators. I don't know whether you were alive during the days of the Kenya Post and telephone. You know, you would go dial something, a guy at a post office would link you to the guy you're trying to call, sometimes queue you because the other guy is trying. These days you just pick your mobile phone and call whoever you want to call. And that guy that now used to see the post office or telecom or whatever, he is now extinct. He's another Homo erectus and if today government advertise job for people to do that, you'll be wondering. So I suspect most lawyers in the next 50 years, in the next 30 years, will be rendered redundant by technology. And it's not just lawyers. There are many other professionals. One of them, which, and it's good we mention, is drivers. You know, when I was young, there were people who did driving as a profession, as a career, as a means of earning. These days, having a driving license is considered some of the routine life skills you need, just like you should know how to iron your shirt, you know. And it's unlikely that in the world of the future, perhaps the cars will be driving themselves. You just purchase a car, it has AI, it has all these links to the internet. You just get on the back seat and tell it, KCK, which is my car. Let's go to Mary. And it will drive itself, it will not collide with any other car on the road, it will avoid any obstacles. And when we reach home, it will ask me, we have arrived, can we stop?
They are even thinking of flying cars.
Yes, flying cars. We already have in the security sector, by the way, and the military world. You know, unmanned aircraft, unmanned aerial vehicles, as they call them, or drones, so that you're here as the commander of the Kenya Air Force, and Kenya is at war with whatever country, and you don't need to put any pilot on that fighter jet. You know, you just send one guy in a control room. He is flying all those fighter aircraft, dropping whatever bombs he has to drop and whatever. and the thing is flying either on its own without human intervention. So we've already seen these disruptions. And the reason I'm giving all these examples from outside the legal world is to show you the legal profession is not immune to existential threats that some other professions are facing, and perhaps the only lawyer that might last for a long time, I don't know whether they also equally be rendered obsolete in the fullness of time is perhaps the courtroom lawyer. Because I don't see how in the foreseeable future, a robot will go address a judge, and that judge is perhaps another robot deciding a dispute involving real people, because there is a lot required at that level that artificial intelligence might take time. I don't want to rule it out, but might take much longer to replace.
But they are already doing e-filing, and us we are already disrupted. And even there is a lawyer who told me that he had to lay off a lot of his employees.
Oh yes,
because he's now working at the comfort of his own.
Most law firms have been forced to lay off employees since the onset of COVID-19, since the onset of these electronic and virtual platforms and whatnot. So basically, the disruption is already underway.
It's all over.
It's already underway, but I don't think many people have a complete view of all the future in the long run of it. There is a book I recommend you read. It's on the shelf there. It's called Omodi. I was gifted that book by one of my former students, and it's a very good prognosis of some of these things we are discussing and how the world of the future will look like.
Yeah, actually, that's about the book. It took us to the second last question. Is there any books or resources or organization that you recommend for individuals interested in learning more about this specific, this public law or law in general? So you have told me that one is about technology. You can recommend for.
You see, public law is a very wide area of practice. So I wouldn't say there is a specific book for public law. But of course, there are specific books for specific areas of expertise in public law. If, say, you're doing public procurement, which I teach, I usually say one must read a now fairly old but very good book by a professor called Peter Maintractor, which is titled Public Procurement Regulation, Understanding the Ends and Means. And basically the book is about why we have all these procurement rules. There are many complaints both inside and outside government saying that the procurement rules are the handicap. That's why we couldn't build the road. That's why we couldn't absorb the development expenditure. That's why we couldn't build that hospital. That's why government was unable within a financial year. They tell you there are just too many hurdles imposed by public procurement rules. But you see, whereas there may be some merit in some of those claims, what you rarely get here is the other side of the debate, which is why do such rules exist in the first place? Because I don't think they exist to stop government from doing development projects. They exist to ensure if government does development projects, then it is done in a way that addresses governance challenges like corruption, like favoritism, like kickbacks, fairness, and whatnot, discrimination. So it's a dicey area. So I always recommend if someone wants to practice an area of public law, then it's important for them to know what are the core reading materials. But even before you go to the core reading materials, I advise that they subscribe to some of the periodicals and the newsletters I told you, from Kenya Law Reports, from the Council for Law Reporting in England, from US Supreme Court, Canadian, Indian Supreme Court. Basically, the reason law is called a learned profession is because it's a profession where one must engage in lifelong
Yes.
reading,
Mm.
research, and learning.
Yes.
And there are no two ways about it unless you just want to be another mediocre lawyer. And it's the same for medicine as well. That's why medical doctors are also called learned.
Learned friend.
Yes.
Very
And
good.
it's also the same for serious clergymen.
Mm.
I don't mean the fraudsters and the ignoramuses that occasionally grace our TV screens.
Yes,
In Kenya, we now live in a world where
Opinion.
your typical grade school dropout and with nothing but a Bible and preaching prosperity,
Yes, yes.
usually in
Prosperity
exchange
gospel.
for tithing and offertory. Then, because of the levels in desperation, you find you become very popular.
Yes.
There's a huge following, sometimes a cultic following. Those are not clergymen, they're just religious fraudsters.
Okay, our last question on last week. First, we appreciate the interview and everything. We just want you to tell the individuals or businesses how they can get in touch with you if they are in need of legal assistance or any advice. Now you are
Great, they
contact.
can visit our website. It is www.muthomikaranja.com. In that website, they will generally find anything they might want to know about us. They can, of course, visit our office. We are on Applewood Adams in the Adams Arcade area in Nairobi. The building is called Applewood Adams. We are on the 12th floor on suite number 1209. Yes. And we are also establishing a Meru office soon. It is currently under renovation. So we will also shortly be having a Meru branch. And those who want to visit, then they can find us in the Meru Business Park. And then we'll be, I believe, on the 7th floor. But like I said, the partitioning, renovations, and furnishing are underway. Hi, my name is Muthomi Thiankolu. I'm a partner at Muthomi and Karanja Advocates, which is a legal practice based in Adams Arcade area of Kenya's Nairobi City. We're in a building called Applewood Adams on the 12th floor, door number 1209. Our main areas of practice are in dispute resolution, tax consultancy, legal consultancy, and general commercial law, with specific emphasis for purposes of dispute resolution of matters in public law, especially those that revolve around public procurement. We can be reached by way of telephone number 020-246-7437. We can also be contacted on email at the email address info@muthomikaranja.com. You can also visit our website, which is www.muthomikaranja.com, in which you'll find a lot of useful information on who we are and the type of legal assignments that we do and how we can be of help to you. Thank you.
Thank you all viewers for being with us throughout this session. My name is Faith Karanja and this is Justice Today and the legal expertise section. And if you have any question you have heard from the lawyer and plus other shows that you will do, then you can reach them and all your questions will be answered. Thank you very much.